this is a direct situation, in my view, for the police to say, very well, you don't actually need to come to us. If we have sufficient cause to believe that you have committed an offense, we issue a criminal summons and leave you in the hands of the court. End of story.
When they issue a criminal summons, will that not make it even more difficult? Because the MPs, they hide under Article 118, and they are always attending to Parliament or returning from Parliament, attending to the business of Parliament or returning to the business of Parliament, even in their bedrooms.
I'm coming. So Article 117 says that civil or criminal process coming out of any court or place out of Parliament shall not be served on or executed in relation to the Speaker or a member or the clerk to Parliament while he is on his way to, attending at, returning from any proceedings of Parliament. And so if we were to go down the hard line, if they picked you up at 12 midnight at your house, that's it. But do you really want to go through that? That's what I'm saying, that we can go through a process. I believe that maybe Articles 117 and 118 are being overextended by Parliament to protect itself. How do we resolve this? I think you should issue the criminal summons and then go to the Supreme Court for an interpretation of 117 and 118. If you believe that Parliament is overextending its meaning to protect its members, let's just go to the Supreme Court. In 3 months, we'll have a decision. And then the story has ended. That's why I'm saying that the institutions exist.
But why do we need to seek interpretation of something that is not ambiguous?
No, the Constitution, the Supreme Court says
that if a member of Parliament is driving right now and commits a traffic offense, okay, jumps the traffic light, the policeman should simply watch him.
No.
Go to Parliament and get the Speaker to issue a warrant allowing the police to pick the person.
No, you're right, and maybe not so right. That is not what it means. But that is what it's been interpreted to mean. To the extent that now the police are even complying with what you believe is a wrongful interpretation. Now, you don't only go to the Supreme Court for interpretation if the provision is ambiguous. It's also if two institutions have put contrasting meanings on the same provision. So here we have the police who believe that, well, this has been overextended. We ought to be able to ask him to invite the MP, him or her, to come in for questioning. And the Speaker says, no, I won't release him. So here the Speaker has assumed the power to be the one to determine when to release, when he says that it is his certificate that the person is attending proceedings that is conclusive evidence. His certificate. He can't say, I won't release him.
Okay.
It is your certificate. Now, if the Speaker issues a certificate that the person is attending Parliament, when the person is indeed not attending Parliament, then that's a breach of the Constitution. It could be a high crime. You see, Samson, the laws exist. So my suggestion will be, police, go to court. Ask for a constitutional interpretation of Articles 117 and 118. Let the Supreme Court tell us the circumstances under which this applies and the circumstances under which it does not apply.